And you've been quite vocal about this recently and have said in a number of places that this, if this trend continues, this will be a court that may be among the most activist in history. What did you mean when you said the Roberts Court is turning into one of the most activist in history?
I should define the term activism as I used it for that purpose. It is a court that is not at all hesitant to overturn legislation passed by the Congress. So to take two very recent headline examples, the Affordable Health Care Act passed Congress, but the court, well, the court held that the Commerce Clause didn't go that far, but thank goodness there was the taxing power that saved the case. But the readiness to strike down a piece of legislation under the Commerce Clause, insurance is surely commerce. It was just astounding to me. But the worst case, I think, was the Voting Rights Act case. I mean, that passed Congress overwhelmingly. I think it was unanimous in the Senate and 330 some odd votes in the House. If anyone knows about the voting rights, how it affects the system, I think the elected representatives have an appreciation of that the unelected judges don't have. And yet, despite the overwhelming majority in Congress that passed the Voting Rights Act, the court said it won't do. The formula is out of date, so Congress would have to go back and take this. The Voting Rights Act passed originally in 1965 on during Johnson's tenure. It was renewed by Nixon, Ford, both Bushes, and it was the second Bush. It was the most recent extension. But the court said it won't do. So I think that's an example of striking down legislation on a subject that the people in the political arena are better informed about than the court is.
I want to ask you about all of those remarkable dissents. But first I want to note how extraordinary it is that you have issued them. I have to say I've known you for a long time. I've admired your opinions, and you've been called a minimalist and a judge's judge. But it seems that in the past 2 years, really, you're on fire. You've found your voice. You are you're sounding like my hero, Louis Brandeis. And it's very galvanizing. You're using words like hubris is a fit word for today's demolition of the Voting Rights Amendment. You have these wonderful metaphors about umbrellas and getting wet. And my question, before we talk about the substance of these remarkable dissents, is what emboldened you or freed you up to express yourself so powerfully recently in a way that you hadn't before?
I had a good model. For most of my years on the court, Justice John Paul Stevens was the most senior judge when we split 5-4, and he was the most senior among the four. He was fair in his distribution of dissents, but he did keep the major cases for himself. And so I was heir to that role of being the most senior judge in on the dissent side.
So it's really a question of your role. And as you say, as the senior associate justice, you have the prerogative when you're in the majority, either to write the decision yourself or assign it to the judge you think will do the best job. And when you're in dissent, you can write the principal dissent yourself or assign it to whom you like. How are you using this power? Have you made a premium on unanimity, and are you trying to convince the 4 dissenters when they're together to all join the same opinion?
Yes, I've met with my colleagues in the Affordable Health Care Act case. I think we spent almost 3 hours just talking about how the dissent should be written. I asked for any suggestions my colleagues had. They saw the draft of my opinion before it circulated to the full court, so I could make sure that I am speaking for the 4 of us and not just for myself. I think it's much easier for the public to comprehend 1 dissent instead of 4. So we make a deliberate effort not to splinter. Sometimes, not often, it's unavoidable, but for the most part, we can come together on a dissent that speaks for all the dissenters.
It is easier to comprehend. There are cases, important cases like Bush v. Gore, for example, where the dissents are split and people didn't understand what happened after the case came down.
Well, that was because there was no time. There was no time to get together. The court agreed to take the case on a Saturday. Briefs were filed on Sunday. Argument was Monday. And decisions were out on Tuesday. So each of us wrote our own dissent, and there was no time to meet and say, let's put these together.
This vision that you're setting out of the 4 liberals being united against the 5 conservatives is very different than the one that Chief Justice Roberts offered when he took office, when he talked about the importance of unanimity and trying to persuade his colleagues to converge around narrow, unanimous opinions to avoid these 5-4 splits because it's bad for the court and bad for the country to make the court look political. Is that a tenable vision? Has he had any success? Is it realistic? Or is the court just going to continue to issue the most important decisions by 5-4 polarized votes?
What he projected as desirable, in his very first term, the court was unusually together. And there's a clear explanation for that. The first term of Chief Justice Roberts was also the last term of Justice Sandra Day O'Connor. So that, her last year, his first year, there was more unanimity than we have seen since. I've said a number of times, and I think anyone who checked would find it's true, that the year she left us, in every case where I was among the 4, if she had remained, I would have been among the 5. So her leaving the court made an enormous difference.
You know, when I teach constitutional law, I always begin by telling students, don't imagine it's all politics. You know, you can think that, but if that's your tenet, then you'll miss everything that's beautiful and constraining and meaningful about the Constitution. But we see numbers like this, and you talk about Justice O'Connor being replaced by Justice Alito, and I have to ask, is it all politics in these high-profile cases? Well, Republicans against Democrats?
I think all of us would answer, surely not. Many times, I will vote or write an opinion that would not be the law if I were queen. So yes, we see this fundamental instrument of government differently. But there's certainly no horse trading at the court. If you vote for me today, I'll vote for you tomorrow. That never happens. And we just have some very different views. Well, let's take the 14th Amendment Equal Protection Clause, for example. Today, the equal protection guarantee extends to women. But if you ask the question, back in 1868, when the 14th Amendment became part of the Constitution, did the people at that time envision that women would be citizens equal in stature to men? And the answer is surely not. But as I see the equality idea, it's there from the beginning, and it is realized by the society over time. So while I would say, yes, it's true that in 1868, women were a long way from having the vote, but then we have the 19th Amendment, and they get the vote. We have a civil rights movement that makes the equality guarantee for race what it should have been from the beginning. And all of that influences or even drives my view of what the Equal Protection Clause means today.
When you tell that story of the expansion of equality coming from constitutional amendments and from the civil rights movement and from acts of Congress, I think I begin to understand the passion of your dissents in cases like voting rights and affirmative action and healthcare. Let's talk about the voting rights dissent, which I think really was perhaps your most extraordinary. You, well, first of all, as I say, the rhetoric was unforgettable. You'd say early attempts to cope with the vile infection of voting discrimination resembled battling the Hydra. Whenever one form of voting discrimination was identified and prohibited, others sprang up in its place. Were you surprised that Texas decided to implement a voter ID law just hours after the court struck down the Voting Rights Amendment?
I expected. Well, that was the metaphor about we put down the umbrella because we weren't getting wet, but the storm is raging. I expected exactly that to happen. Now it's a problem what to do. The voter ID laws, closing the polls early, putting them at inconvenient places.
So the Attorney General has asked a federal court to require Texas to get advance approval before putting in place some of these political redistricting or other changes. Are Sections 2 and Section 3 of the Voting Rights Act, which remain, adequate alternatives, or might the court, cut back on those as well?
I can't predict what the court will do, but perhaps we should explain what Section 3 is the bail-in provision, right? And so the Voting Rights Act, one of the reasons I thought it was unquestionably constitutional. So suppose a state that was, in 1965, one of those states that did not allow African Americans to vote. But over the years, they had changed their ways, and they were no longer keeping any people away from the polls because of their race. If they have a clean record for 10 years, they can bail out. And on the other hand, if a state that was not in the group that were required to pre-clear voting changes originally, those states or districts could be bailed in. So there was a way to take out political units that didn't belong there and add ones that did. And that was the mechanism that Congress provided. But I don't think there was anything said in the majority opinion about the bail-in, bail-out.
Courts, though, have imposed a very high requirement of intentional discrimination before allowing states to bail in, which is why very few have bailed in, and these suits may not succeed for that reason.
Yes, that remains to be seen.
And Section 2, similarly, also requires a high degree of intentional discrimination, and even though Congress tried to lower the standard, the court has cut that back as well, so it's a similarly uphill battle.
Well, Congress said it's discriminatory in effect, even if you can't prove intent. But what the court will do with that is an open question.
But so much of the power of your dissent came from the need, as you said. Congress legitimately concluded that pre-clearance by the federal government was necessary because unless you could challenge these second generation of voting discrimination in advance, the hydra, as you put it, would return. So tell us more about that.
Different forms. The original devices were blatant. There was no disguising what they were doing. The literacy tests in the old days, well, just the intimidation of black voters, even if they were able to get to the poll to register, there were people stopping them from doing that. I mean, it was a violent history that accounts for the Voting Rights Act. And then over time, those devices, those crude devices pass, but more subtle devices emerge, like putting a polling place in an area that's inconvenient for minority voters to reach, or opening the polls late and closing them early, making it difficult for people who have jobs to come and vote. Redistricting, more subtle, more sophisticated devices have replaced the old